Evening or good morning, wherever you are located and tuning in from. I am Jaya Sharma. I'm an arbitrator and a mediator located in the United States. Unfortunately, I cannot be in Uzbekistan in person, but I'm happy to be doing this virtually. With me today is Vivek Kapoor, my co-moderator, who is a barrister at 39 Essex Chambers in London. And also a very distinguished panel. But first, let me welcome you to this session. It's India Bound. Will Uzbekistan become the next preferred seat for Indian users? So today is the fourth day of programming for the Uzbek Arbitration Week. And I'm sure some of you have attended prior sessions. I did. And many of the sessions have focused on the recent trends that are emerging in arbitration in the Central Asian region. And it was very interesting for me to hear that in the last decade or so, arbitration, particularly international arbitration, as a way of resolving disputes has burgeoned. And it's become very, very popular, and more jurisdictions are trying to establish centers in their geographical area. I heard a very interesting statistic in one of the sessions yesterday, and I was surprised to hear that there are over 90 arbitral institutions now all over the world. Maybe there are more, but these are the ones that have participated in a survey that was conducted to get their opinions on investor disputes, how to resolve investor disputes. So TIAC is one of the new arbitral institutions that has appeared on the arbitral landscape. And today's session will focus on, how some of the elements which are crucial to an arbitration, whether some of these elements are prevalent or they exist in Uzbekistan, and particularly in the TIAC rules and TIAC center, for it to be conducive as well as an attractive seat for arbitration. Now, because of the burgeoning number of centers, parties don't have to resort to the LCIA, AC, or the ICC, or the ICDR, or the AAA to get their arbitration, to convene their arbitrations and to have the disputes resolved. So as I said earlier, we will analyze the TIAC rules and the center against the backdrop of some of these elements. And the elements being, what are the arbitral rules like? How are the arbitrators appointed? What are the role of the courts and the local judiciary? What about the enforcement aspects of the award, as well as some of the softer issues related to the center itself, where the arbitrations might be held? So, as I said earlier, we have seasoned dispute resolution professionals who are our panelists today. And I'm going to have Vivek introduce them shortly. But before we proceed, there are some housekeeping matters that I would like to bring to your attention. This session, if you're looking to find a PowerPoint, you will not find one because we're going to have an interactive panel discussion. So, please, if you have any questions, please keep your questions put them in the chat box, and we will allow 15 to 20 minutes at the end of the session for a question and answer period. With that, I'm going to turn it over to Vivek to introduce our speakers. Go ahead, Vivek.
Thank you, Jaya. Thank you so much. It is our pleasure to be here with you today. We have, as Jaya has already told you, we have a brilliant panel. So what I'm going to do is I'm just going to look at my screen and introduce our colleagues here. And if you don't know them, you will see from their difficult smiles who I'm talking about. So the first on my screen is Farhad, who's a partner at JSA in Mumbai. You see the smile. Then is Ashish, a partner at ELP in Delhi. Then we have Chakrapani, who's a partner at Keban & Co. And then we have Shank, who is a partner at Trilegal. For all of you who don't know, they're top law firms, and all these gentlemen are practice leaders and some of the top international arbitration lawyers we have here. So it's a great, wonderful panel we have here, and there are some very interesting themes we're going to explore with you today. But the question a lot of you would be wondering is, why India bound? You're sitting in beautiful Tashkent and you're talking about India. Why is that? Well, to put it simply, India is a massive exporter of international arbitration. So if you look at the SIAC figures, you look at the LCIA figures, you look at the ICC figures, you look at the HKIC figures, Indian parties play a very important role in putting those numbers up there. Now, I don't know about AAA, but I'm sure Jaya will tell us in due course. Now, what I'm going to do is not waste time, and let's get this started. As Jaya's already said, please put in your questions in the chat function, and we will try and pick them up towards the end of the session. We've kept 20 minutes, and we hope that will be sufficient. Jaya, back over to you. You're on mute, Jaya.
Yes. Okay. I mute myself so that there's less background noise. So as Vivek has just mentioned, what we're going to do now is to focus on certain aspects of what makes a successful arbitration. So I'd like to first start off the discussion by asking Ashish to talk about the arbitral rules and to do some kind of a comparative analysis of the rules, because he's practiced in various jurisdictions and has used different arbitral rules. So how does the TIAC rules, how do these rules compare, say, to the rules of the ICC, LCIA, ICDR, AAA, and SIAC, and others?
Thank you, Jaya, and thank you, Vivek, and to my fellow panelists and to the listeners at large. When I looked at TIAC rules for the first time, or let me just actually confess that when I heard about TIAC for the first time was barely about 2 weeks ago. And I must say, till about last week, I had not looked at the TIAC rules at all. But when I did look at that, I did find that it's a beautiful amalgamation of all the other arbitral rules. And I think it comes clearly from the experience of Diana, who's already here, who's very experienced and having worked with many rules across the world, has been able to bring together a very robust system here. It is visibly, I would not say last movers, because we are singing, as Jaya rightly mentioned, that we are probably 90th or 91st arbitral institution right now in the world, which already exists. But I would say that I would give the credit that it visibly the latest movers advantage I see in TIAC rules here. And that advantage is so visible that why would I not go to TIAC instead of choosing any other rules anywhere else in the world? And just before we started our discussion, we were talking about in what time zone Jaya is sitting and where we are sitting. We are only 30 minutes away, sitting in India, on a time zone difference at this point of time between Tashkent and Delhi. I think not only this actually already makes it very inviting for us to be working on a similar time zones. The other incentives which I see being brought forward in the TIAC rules is it is definitely very, very competitive. It's giving incentives like no VAT on either the arbitrator's fee, no administration fee. I haven't seen it anywhere else so far. We don't see income tax on arbitrators. It definitely is a great motivation for international arbitrators to really lend their time and to invest their energies in supervising arbitrations at TIAC. uh, and a lot of experience can actually already been seen to be gathered when I look at the list of panel of arbitrators already existing at TIAC. See, what we are looking when we are looking at a TIAC as a destination or SIAC, or when I compare with HKIC or any other international arbitral tribunals, we look at impartiality. We look at, obviously, apart from enforceability, which is governed by the substantive law, but we definitely are looking for a client to have a very impartial, a very neutral venue, and which also has the capability of providing world-class arbitrators. When I talk about world-class arbitrators, it's rare that in today's time, we would not be looking at younger areas of dispute, which may be intellectual property, which can be technology, or which can be sports, rather than going to only Geneva. I would say if TIAC can, and as it has seemed to promised, provide specialized arbitral tribunals to look at these specialized areas of law. And I was very, very pleased to see they have advocated very well about technology arbitrations to be administered very competitively at TIAC. It's not that other tribunals cannot do it, but a young tribunal, under the rules of TIAC, within 2 years, having seen 22 international arbitration references, and with 2 emergency arbitration references, it is commendable, I would say. And one very important part I've seen over a period of time is that while we mushroom many arbitral tribunals and many arbitral rules, but I think TIAC seems to be coming forward as Uzbekistan centralized repository, and it can be the way I'm seeing with the support of the government. And when I say support, I'm very, very conscious of using the word support. I don't see in their manifesto anywhere a direct interrelation between the government, judiciary, or the panel of arbitrators or administrators at the TIAC, which is again a sign of impartiality and independence at the same time. And as compared, I would only reiterate that point, that no doubt it has brought out the best amongst the current arbitral rules all across the world. And I'm really looking forward. I think apart from, as Jaya rightly mentioned, there are softer issues also in play. And the softer issues including the fact that time zone difference actually, and how conducive it can be, and how comfortable it can be for parties in different jurisdictions to actually congregate from Delhi. And I'm sitting in Delhi, and I do often advise my clients where would they choose to arbitrate and why would they go there. Having a 2.5 to 3.5 to 4.5 hour difference makes it a little uncomfortable for us. And if we get a conducive, very neutral venue and with expert, stellar panel of arbitrators, I would not hesitate to actually recommend TIAC to be one of the next destinations to be there. I think there's one point which I did want to mention. There's a lot of impartiality and there's a lot of independence given to the tribunals on prescribing its own rules and timelines. I particularly mention this because we have seen some changes in the Indian Arbitration Act, and it has really gone through many changes here over the past couple of years. It is very important to recommend that we bring in some kind of a timeline, because apart from being great panel, it's also very, very important to be closed timeline for completion of an arbitration proceeding. Indian Arbitration Act has brought in a 23(4), which actually speaks about within 6 months' time, you must finish all your claim-related and defense pleadings. And that, I think, although it does not really bring a bar to or a limitation within which time you have to complete it, endeavor being endeavor, but if you do put some strict timelines out there, it does really give a lot of confidence to parties who are congregating together for a dispute resolution before any tribunal. So that'll be one small recommendation I'll bring in, but other than that, I don't see a reason why it can't be, in fact, to a large extent, a better choice than many arbitral tribunals in India so far today. Over to you, Jaya.
Thank you. So I just would like to add a few more points to your presentation right now. And that is, in looking through the rules myself, I found that they have a very strong confidentiality provision, as well as, for me, that's very important because I sit as an arbitrator, immunity for arbitrators under Uzbek law. Would that be something that is of importance to, say, arbitrators and others sitting there in on a tribunal?
It does, Jaya. In fact, I thought we will come back to these points as we deliberate more on this. This is, in fact, one of the greatest pearls of in our TIAC arbitration rules, actually, because I don't have to really stress on the importance of how confidentiality, the extent of confidentiality, to what extent it applies to the entire arbitration process. It's a great boon, I must say. In fact, just to add to that point, to the extent that it actually allows the arbitration practitioners to come and assist their client, being international practitioners, not only before the tribunal but also before the court of law. I think that's really a step forward, and that also bridges the gap of understanding between a solicitor who advises a client, who sees them through a dispute before a tribunal, and in case of an appeal or a challenge, he is able to take it through to the court, and the client definitely would feel very, very comfortable in bringing in their own representatives throughout the proceeding. I think that's also a great point, which TIAC rules actually provide for already.
One last point, and then I know we're going to be discussing more about on these issues a little later, but I just wanted to introduce it here. And that is, I think if you have, U.S. counsel will be advising your clients, say, to choose Uzbekistan or Tashkent and the TIAC as your seat. One very attractive feature that I read in the rules was the fact also that there is no need for foreign lawyers or attorneys or counsel representing clients to actually get a license from the Uzbek bar, as is the practice in a lot of jurisdictions where they are protective and they require foreign lawyers who are not licensed to practice in their jurisdiction to actually go get a license. So I think that we've had a pretty good discussion on what the rules of TIAC, what they say about arbitration and how attractive they might be to users in India. And in the interest of time, I think I'm going to move to another topic, which I think Vivek will introduce.
Thank you, Jaya. Thank you so much. We've talked about the rules. Now, the next important aspect when you're choosing a seat is the supervising court and the attitudes of that. And I'm going to explore that theme a little bit with Chakrapani. Now, Chakrapani, Indian businesses are some of the most dynamic of the world, and I'm sure your clients take you to all sorts of places. Now, if a client gives you a call, or one of your corporate partners gives you a call and tells you that, look, the client is keen to have a seat which you're not very familiar with. So we're now not talking the London, Singapore, and Genevas of the world. We're talking the Tashkent, a place which is up and coming, but a lot of us don't have any experience of it. What are the factors that you sort of look at in terms of the attitudes of the supervising courts in advising the client to, choose a seat or not to choose a seat? Chakrapani?
Thank you, Vivek. And thank you, Jaya, and my co-panelists. It's a privilege to be here and talking to some very distinguished professionals across the globe. The question of judiciary, that goes to the very core of independence of arbitration process. And judiciary has the power, the courts and judiciary has the power to either make a seat a very attractive destination or it can completely mar that process, and arbitration can be like the international community would like to completely avoid that jurisdiction where courts are interfering. So few things based on the best practices of these great centers that you mentioned, few practices that can really help in an arbitration friendly jurisdiction is that the courts must adopt a non-interventionist approach. That's very crucial, because court can be supportive and court can be interfering. So if it has to adopt the supportive approach, it has to start by being non-interventionist. Point number one. Secondly, when it comes to the help of the international arbitration, what the judiciary is expected to do is that it is supposed to lend a helping hand. So when it comes to giving your interim injunctions before the tribunal is constituted, or where a request is made by the tribunal to assist in evidence, or whether a request is made by the tribunal for recordal of evidence in some cases, court should help. At the same time, court should step back from a few things, which in my view are absolutely crucial. And some of these things are that one is, of course, that court should not be granting anti-arbitration injunctions for the asking, because that kind of creates a very negative impact on the overall arbitration atmosphere. Secondly, don't interfere in a situation where arbitral tribunal is already functional. So there are jurisdictions where you have arbitral tribunal fully functional and still parties approach and try and get some kind of injunction while the tribunal is functioning. So it kind of gives a very negative approach to the arbitral process. Third is that when an award comes for a challenge before a tribunal, before a court, the tendency is to look at that award from as if it is a decree coming from a inferior court's judgment, which should be avoided. And I was very pleased to see that the modern law of Uzbekistan, where as far as international arbitration is concerned, it's very clear that the arbitrator, the court's authority is only limited to the extent where the grounds are mentioned. So that is a very welcome aspect. So that's something that these are the aspects where courts have to be conscious, judiciary has to be conscious that they do not overstep. They support, they lend a friendly hand, but at the same time, don't interfere in the process. So if judiciary can strike a balance between supporting and non-interfering, in my view, that will be the perfect match. Now, only one word of caution here before I conclude on this is that the laws are very new here. And I was very impressed with the Uzbek laws, and I was very happy with the rules, which as you rightly summarized, the best of, and my earlier panelists summarized, that is the best of the best practices all over the world. So rules and law are perfect. It's just that how courts interpret it and what kind of approach they take will decide how attractive the destination will be. Over to you, Vivek.
Thanks, Chakrabarti. I'm going to ask you another question, but I'm going to also request you to speak slightly louder because I think the interpreters are having some trouble. Now, you raised a very interesting point. Non-interfering laws, non-interfering courts are very important. But when you're looking at a jurisdiction like Uzbekistan, a seat like Tashkent, you have all the right ingredients, but maybe there aren't too many precedents. Now, what are your top 2 tips when a client lands up in arbitration to make sure that they don't get into any rough feathers?
Well, two top tips would be, given that I have the freedom to choose the set of arbitrators and the set of substantive law, my first advice would be to choose a substantive law which you are familiar with. And second would go logically that I would advise to have professionals who are well versed in that law. And luckily, the way the rules and the law is framed, that it allows both. So that's what I would suggest.
I think those are very important points, and I think they are the sort of key ingredients that when you land up in a new place, those are the things you need to be careful about. So thank you, Chakrabani, for that. Jaya, this brings us to a very interesting aspect of the whole arbitration process, appointment of arbitrators. Now, I know that you sit as an arbitrator as well. What are your thoughts about the process?
Well, thank you, Vivek. The appointment of arbitrators. This is a very, very critical and crucial, I think, of a successful arbitration, the selection of the panels. So if you are doing an arbitration under a particular arbitral institution, then they have a set appointment procedure. But if you're doing an
let me play the devil's advocate. Let me ask you a question. Now, I know, a lot of us who sit as arbitrators also work as counsel. So, we have a slight bias of that. Now, as an arbitrator, it's very rare that we have arbitrators whose mind we can pick. So as an arbitrator, what is your advice to counsel who are picking arbitrators? What are the factors that we should be looking at?
I think you should look, first of all, for someone who is going to listen and who will review all the evidence that has been submitted, somebody who will be impartial. I mean, when I say impartial, it means you have to make sure if you've been appointed by a party that their side gets in, but not to advocate because you're not their counsel. You are there as an impartial member of the tribunal. Now, there are some here local arbitrations that are done under the AAA where they are definitely, party appointed, and so they can advocate for their particular party, but I would not recommend that. I think that the whole process rests on the foundation of impartiality of the tribunal. And I think that the more impartial you can be, the better the outcome will be. I know that when I was learning to be an arbitrator, we were told when you write decisions, write the decision for the losing party so they understand why the decision was made the way it was. So similarly, I think you need to be, the first important thing is that you need to be impartial. And I think in today's world, when you're looking at really very complex types of disputes, you need an arbitrator also that has the knowledge, substantive understanding of the subject matter and also the law. So yes, you can have experts. This is a big debate. Do you really need somebody who understands the process versus somebody who has the substantive knowledge? I think both these aspects are important.
But if you have to choose substance versus process, what should people choose?
Maybe I'm biased because I feel that I can be a good arbitrator. And I say, well, I can rely on experts. They always have experts anyway. I'm not an engineer. So if there are some engineering related aspects of the dispute, there are experts that will illuminate the arbitral panel and educate them. So it depends again on the dispute. There's certain very, very complex disputes, I think, where you do need to have somebody. Maybe one way of doing it would be to have a diverse panel where you have people with different expertise so that when you deliberate, you have the perspective then of that person who has that substantive knowledge. When I say substantive knowledge, I also mean not only of the law, but of the particular subject matter.
Thank you. I'm going to ask Ashish to comment, but before that, I'm going to add one point to the wonderful points you made. I think a very important aspect when I am appointing an arbitrator, I look at is obviously all the factors you talked about, but also how their diary, how available are they? Because a problem I have seen is sometimes you get superstar arbitrators, brilliant people, but they're absolutely so busy. you can clearly make out they're not reading the pleadings. They're just sort of playing it off the hoof, which can be very frustrating. If you're a party that's looking for, tidbits of relief, you should always prefer a more proactive tribunal. I think a tribunal should not be the shepherd, but the tribunal should be proactive. And I think that is something we should all look at when we're appointing arbitrators. Ashish, quick comment.
Sure. Thank you very much. I'm in fact picking it up from what Chakwani mentioned, in fact, and I've been holding on to the thought. There is one point which we must actually always keep in mind, that Uzbekistan is a civil law as against our common law jurisdiction, actually. And when I go within India to different states to fight my disputes for my clients, I always believe that although they are governed by the same law, the central laws, all over the country, but how the courts and how the judiciary there reacts to a particular manner of speech or process, it's very important for us to be conscious of it. We go backwards from the relief. We never file pleadings. We never make pleadings starting from who am I, who they are. I go backward from what I want to get, and is the entire process conducive for me to achieve that objective or not? And I think one of the important considerations for, if I'm ever advising anybody to go to Uzbekistan, I would say, let's talk to a civil law expert once before we take the first step forward. And I just thought on that issue of enforcement, and picking up from what my colleague Chakwani mentioned.
You make a very interesting point, and I'm going to actually get all the panelists to comment on that. But I'm going to start with you, since you made that point. Civil law versus common law. How much is it a concern for you when you're recommending a seat?
Well, it is, in fact, to the extent of a challenge. What really applies is the seat in India. For example, if I have a seat in India, the Indian Arbitration Act would apply in the procedure, and they will, to that extent, it will be non-derogable, in fact, by the rules. So I'd be quite concerned about it, that what is the supervening law? What is the supervisory law? And to what extent I'll be able to pay my tricks. Well, let's all be very fair. We are going to represent one party, and we are going to be aiming at the relief. We are friends outside. We are very, very conducive. We are happy to talk very, very confidentially. I love it. I already love the fact that the confidentiality extends to the fact and existence of an arbitration in the TIAC rules, in fact, so that nobody can talk outside of it. That we have an arbitration and we have a dispute with the party, so there's no advantage of mudslinging happening outside, and that's actually a great benefit, and it's a great cushion. But at the end of the day, I can't lose sight that I am out there in a very let's say, I'm very amicable surrounding, but I'm out there to win. I'm out there to win. So I'm going to be very, very concerned about it.
Chakrapani, your thoughts quickly?
I agree with Ashish completely, because here we are to represent our client and to win. And that cannot be lost sight of. Having said that, if it comes to that, it will bother me only to the extent that I don't know the law. But so long as I'm aware of it, or I can be made aware of it, and I satisfy myself that the process is going to be fair as far as courier law is concerned, I'm good with it. So it's like it has to be something that I have to test waters, or I have to be sure of before I advise my client to jump in. So to that extent, it's crucial.
Thanks, Chuck. Right, Jay, coming back, I think we need to close the loop on this one. I have I sit as an arbitrator, but I have never ever sat in a civil law dispute. It's always common law, even laws where I may not be called, but it's always common law. Have you sat in civil law? And if you have, what are the considerations that are there at the back of your mind? Because I know, like all of us, you have a common law training.
I'm sorry, I have primarily sat on disputes where it was common law. So I can't really comment. Maybe there are others here who might be able to comment. But Vivek, I wanted to just bring up one very important aspect of the selection of and appointment of arbitrators, and that is relates to this whole topic about diversity. I mean, every arbitral institution today, they talk a big deal about diversity. We value diversity. And they have all these different organizations have signed diversity pledges. What really is happening? I mean, I think that we have to have a new approach to that topic and that to resolve this issue where the panel of arbitrators or the rosters are dominated by a certain gender or also arbitrators from a particular geographical area.
As they say, pale, male, and stale.
Yeah, exactly. I didn't want to say that because, but I'm glad you brought it up. As everyone says, PMS, right? Pale, male, and stale. Well, that's no longer the case because now international arbitration is the day, and wherever you go, people are resorting to, especially cross-border disputes, to look to international arbitration. So I'm just going to leave you with one thought here, and that is I also am the former chair of the American Bar Association's section on dispute resolutions diversity committee. Our section signed a pledge or a resolution, and the resolution again mirrors what you've seen all the other arbitral women and some of the other organizations' pledges. But I think we need a paradigm shift, and the paradigm shift is not for counsel alone to select the arbitrator, but the entire community, meaning the disputants who are choosing counsel, but also bring them into the discussion loop so that you can have some kind of a comprehensive look at, how to select the arbitrator, and that you're not going to the same old individuals who may not be the best just because they happen to be arbitrators, say in the 1990s when it was a burgeoning and an emerging type of dispute resolution. That doesn't mean that they are really the best. And also, as Vivek mentioned, some of these sought after arbitrators have very heavy calendars and diaries. And I've had some colleagues in Europe who've said, we have to wait 2 years to get a hearing. I mean, the very basis for having arbitration, one of the tenets of arbitration is that it's efficient, as well as, disputes can be resolved in a very timely manner, unless a court docket. Maybe compared to India. Sorry, I don't mean to point fingers at India, but there's so many cases on the docket in India that it sometimes can take 10 years before your case is heard. But I think, especially in international arbitration, they're looking for timely resolution of disputes. And if you have to wait 2 years to have a hearing, I think that defeats the very purpose of going to arbitration. So Vivek, I know we have other topics. Should we move on?
Yes, let's do that. But I think I should say that if you instruct anyone on this panel, I'm sure they can ensure that the disputes don't last 10 years.
So should I now move to another topic? I think Ashish mentioned this earlier, and that is the importance of post-arbitral awards and the enforcement aspects. That is very important. And so let's have a little bit of a discussion, and I'm going to turn to Shank to lead us in this discussion. So, the arbitration is over. You've got an award. What are some of the concerns you have?
Hi, good evening, everybody, and thank you for the introduction. So I think as we have developed as a community of lawyers and corporates who've absorbed and really embraced arbitration as a process, the process of arbitration has now become much easier than how we would play with it, say, 20 years back. The biggest difficulty now, which is still outstanding, is enforcement of an award. Now, it could be a domestic award in any country or a foreign award from any other country. Now, and honestly, this enforcement of arbitration awards from any jurisdiction could could be a topic of discussion for 2 hours on another day. But I will just be very narrow in this discussion because the discussion here today we are doing is to ensure how can we make TAC successful, right? Now, when we look at TAC, we'll have to further categorize into 4 different aspects. One is an India-seated arbitration adopts TAC rules. Right? Now, let's just take that up front. I think the rules as such, as Ashish and my previous panelist also indicated, they are fairly robust and it complies with all principles of common law, natural justice. So I don't see any huge difficulty in adopting a CAC or a HKIAC or a TAC for that matter. So I think there we are quite clear and well home. We've also noticed, at least I've also noticed, emergency arbitration process, expedited procedure, all of that's there. There's elaborate discussion and provisions around discovery and interrogatory. So everything that you would want from an arbitration process is envisaged in these rules. So I think that is a less of a difficulty. Of course, any award, whatever rules we apply in terms of the process, the challenges for enforcement, when I'm speaking from India, I'm saying challenges for enforcement in India will remain the same. And the rules will not dictate whether it's difficult or not, at least to my understanding and my reading of the TAC rules. It does not violate any common law principles or Indian law. Now let's look at the second aspect. What if we choose TAC rules with a seat in Uzbekistan? Here we land up into some kind of controversy, as we just discussed, given the fact that the law of the seat, if seat is Uzbekistan, will be civil law. All that we need to ensure is the process for challenge, appeals, or interim protection, they are not in conflict with the law of the country where eventually that award may need to be enforced. And why I say this is, when we look at a foreign seated arbitration award in India, and thankfully Uzbekistan is a New York Convention country, so we are home there. When we bring such an award to India, you can't challenge it in India, of course, but what you can do as a judgment debtor can object to the enforcement, and the objection are on fairly limited grounds, but I must add those grounds more or less come from a point of view of following of natural justice principles. And also, while it's not said so clearly, if an enforcing court is required to look at a situation where the award is based on a civil law construct which is in contradiction or conflict with Indian common law or Indian public policy, it is quite likely that the Indian court may not enforce. Now, therefore, all that we need to ensure on as far as Uzbeki law is concerned before we choose that seat is to see what is the level of conflict of laws in terms of the procedural interface that one would have to face in the event the seat is chosen to be Uzbekistan or Tashkent for that matter. While it's one thing to say that Uzbekistan follows civil law, to the best of my understanding, I would not expect a huge amount of variance in terms of the process, because end of the day, over the past probably 3 decades, be it civil law countries or common law countries, everybody is going more and more towards commercial laws than just based on the previous historical ideas of common law versus civil law. So I don't see that as a challenge, but still, when I'm choosing, I need to, perhaps I will engage another Uzbeki lawyer who could advise us on conflict of interest at a perfunctory level, and so that we are more informed. And in the event, and this is more for Uzbekistani lawmakers to ensure that if Uzbekistan needs to be a welcome seat or a preferred seat, their procedural laws and curial laws also have to be consistent with commercial laws the world over. Now, the third aspect is, if I were to get enforcement in India, right now, and I'm assuming now the rules are TAC, seat is Uzbekistan. Enforcement in India, the short point is, unless there's any conflict of laws, it should be enforced. The Indian law has also progressed substantially, which gives more and more credibility and credence to an arbitral award, which has been passed, be it in any country, and more so if it's a New York Convention country. So I don't see a huge amount of challenge unless there's conflict of laws. The third and more important here is, it may also be a scenario that parties choose Uzbeki seat and perhaps Uzbeki law or Indian law with TAC rules on the assumption that there are assets of the disputing parties or joint assets of both the parties located in Uzbekistan. Now, what we need to really understand as lawyers advising our clients is how easy or how difficult will it be to enforce an award in Uzbekistan, right? Now, one, the volume of business will obviously rise over the years, hopefully, between India and Uzbekistan. Having said that, that cannot be the only reason why TAC rules are adopted or Uzbekistan as a seat is selected. Uzbekistan as a seat can also very well come into play if there are other countries or parties from other countries who are contracting parties with Indian parties, right? Now, it is possible for such parties to choose a neutral seat, and where Uzbekistan or TAC rules can come in fairly handy. But for that, for clients or for parties to make that determination, I think they, if not already done, Uzbeki law needs to, again, align itself with international commercial principles, lex mercatoria, as we say, and ensure that, if you're targeting a specific market from where arbitration will generate it, it should definitely not be in conflict with such municipal laws. I think I'll just pause here for a moment and wait to hear reactions from any of my panel members, or Jaya or Vivek.
Shank, thank you for that wonderful analysis. Would any of the other panelists like to comment?
I had a question for you, Shank. You raised a very interesting aspect about making that difference at TAC rules, India seat, TAC rules, Uzbeki seat, TAC rules, and Uzbeki law. Tell me something. In your experience, when you're trying to enforce an award which is not coming from an established institution, or rather a mature institution like an LCIA or SEAC, you have a civil law regime which the Indian courts might not be familiar with. You come in with an English law award, they understand it. What are the challenges, and how can parties overcome those challenges? You're on mute, Shank.
Yeah. So thank you. That's a very interesting question, and I honestly also have to admit that there are not too many instances where Indian courts are faced with civil law being the governing law and the award is based on such governing law. Having said that, I have in fact had the opportunity to do a few of such enforcement scenarios, and pleasantly to my surprise and my understanding, the Delhi High Court was fairly welcoming, and I'll also try and explain why it was so. I think the overall context with respect to arbitrations and enforcement of arbitral award in India is becoming very, very pro-arbitration. So irrespective of the underlying governing law, the initial tendency of judges is to assume that this is a good award, must have been presided over by retired judges or counsel of repute in those jurisdictions or some international jurisdiction, unless a party is able to show specifically that enforcement of this award will be in contradiction to Indian laws. Indian courts have gone ahead and passed orders to enforce, and well, enforcement and getting money is another matter, but they would definitely proceed to take necessary steps in that direction. And honestly, I also have to admit that this was honestly not the case, say, a decade ago. We would still need to go to especially if it's a district court, let's say in a state like Haryana or Rajasthan, and you're before a district court judge, you will probably have to spend a couple of years to make him first understand the Indian Arbitration Act, what this newer convention means, and the fact that I'm proposing to enforce a piece of document which is, let's say, an award from an Italian seated arbitral tribunal. I have to first tell the judge, look, you have no business in analyzing the merits of the matter. So don't start taking evidence on this. And this used to happen. Thankfully, we've moved on substantially well from there, and judges don't really seem to get bothered about it. Yes, of course, judges are conscious that our law, our Arbitration Act, provides a full-fledged process in the event a counterparty or any party wants to project or wants to substantiate how it is conflicting with Indian laws, in which case the judge will obviously take it up. But I honestly don't see a problem. There's no subconscious bias against, or a conscious bias against an award coming from a civil law country, and especially definitely not if you are before the high courts of any of the states in India. I hope I have sort of answered your question, unless
No, that's I think you absolutely have, and I think that's been, in my limited experience, the same, that in Indian courts are receptive. They're not just looking at it has to be from a massive institution, it has to be a name they need to understand. I think there has been a dramatic change in that. So I think it's a very welcome thing. Jaya, back to you.
So I think, Ashish, did you have a comment about enforcement?
I think, thank you so much, Jaya. What Shank has mentioned is very, very clear. I mean, I don't think it really is an impediment that it's a civil versus common law. So long we have very limited grounds of challenge when a foreign judgment is or a decree's award is sought to be enforced in India. It's very, very limited, actually. And like you rightly said a little while ago, that it's essentially, or Vivek also mentioned, that it's essentially natural justice. If it is not so apparent that the award is obtained by fraud or by an incompetent jurisdiction and opposed to natural justice, there's no reason for us to believe that it would be. And in fact, obviously, to that extent that we have to give it to the Indian judiciary, which is very, very proactive now to really look and respect the arbitration proceedings which has commenced with the consent of the parties, where the party autonomy has been the paramount impetus. And there's no reason. I don't see a reason. In fact, Shank very validly pointed out that point, that we are not averse. So that means the judiciary also has a very important role to play, to see, you just can't come and seek a stay of enforcement on such grounds which were available to you, which you were aware about, and right at the time of entering into that contract and arbitration agreement. So today you can't say, after having crossed through the entire river, that, oh, sorry, we started wrong.
Yeah, just to add to that, I think in an overall context, if I were to look at and give an opinion on TAC rules, I think one would not hesitate to, or parties should not hesitate to choose as an institution. Only a few things the arbitral tribunal should be careful, and I'm sure the parties involved will be assisting them. And there are things like the document has to be properly signed, stamped for enforcement in India. So as long as those small procedural steps are taken, and there's no big major conflict of laws, which I don't believe there should be, I think this is definitely an institution which can be a preferred choice for clients.
Wonderful. Thank you. Now, changing gears slightly, we've talked about the rules, we've talked about the seats, we've talked about the law, we even talked about post-award enforcement. But arbitration also has the sort of softer aspects which motivate lawyers to choose seats, which motivate clients to look at certain seats, certain rules. Now, we're going to talk to Farhad about it. Farhad, in your experience, what are these softer aspects that do influence parties' choice of rules, seats, and other actors?
Yeah, well, thanks so much for having me in. Pleasure to be here, and thanks for asking me here. Um, as we've heard from everyone, really, and it's beyond dispute, that there are an enormous number now of arbitral rules and jurisdictions and venues available to anyone who's contemplating arbitrating. A lot of the rules are similar. Some of them are identical. You therefore have reached a base level where you don't have to worry about a rule being a problem. And there is no question about the fact that the TIAC rules, as I've seen them, are absolutely up there with any other rules that you can look at or think of. So I don't think there's any problem there. That being said, what then happens in terms of implementation and execution during an arbitration? That's what's really important for people when they decide whether to go here or there or wherever. So what is important for Indian clients, because that's really the subject of what we're talking about, at the top of the list is costs. Second on the list is costs. Third on the list is costs plus slowly diminishing into other issues. And what TIAC seems to have uppercut a lot of the other institutions in doing is to have not kept any secretariat fees. And that's really important, because secretariat fees can be fairly hefty depending on which institution. ICC traditionally is probably the most expensive. And if you look at the newer ones as they've come along, they have all tried to be more cost effective on secretariat fees. And that is actually quite interesting. And this, what TIAC seems to have done, is extremely interesting. And what is also fantastic is this VAT exemption. What needs to also be borne in mind, and this is something that one has to be careful about, is that your secretariat is the front face of your entire institution. And it's very important that by being perhaps the cheapest, you don't compromise on the quality that a party or lawyers are seeing in terms of what they're getting back. We all have had experience with the ICC and with the PCA and with LCIA. There are case managers who are extremely efficient. There are other case managers who are perhaps not so efficient. And so it can be variable.
To put it mildly.
Yeah, exactly. I mean, we've torn bits of our hair out sometimes. But the simple fact is that we must be careful, the TIAC must be careful to ensure that there is real efficiency in the secretariat. That being said, it's a fantastic thing that they are waiving any secretariat fees. Time zones, of course, correctly mentioned, very important, very useful to Indians that it's in the same time zone. I didn't quite see, and it's something which might be of some interest, what in the cases that have been dealt with so far, what has the average time taken been for disposing of these arbitrations? I may have missed it, but it's interesting to see. The issue regarding common law, and I'll come to that, and codified law, and I had some experience with that, with having to do something with a Swiss law matter and dealing with the Swiss code. It's not easy for us to wrap our heads around as common law jurisdiction lawyers. One has to involve civil law lawyers from probably the jurisdiction of the law concerned at a much earlier stage than you would imagine, right at the beginning. because there are issues on that law which arise right from the beginning. In that sense, that is one of the problems. Not a problem, it's perfectly surmountable, as everyone else has said. But there is a comfort in knowing the positions. So, for example, when you're dealing with English law, you know the positions. There may be nuanced distinctions, but you know the positions with common law jurisdictions. So that is one thing which, really speaking, I don't see it as the others have pointed out as being much of an issue. Then we come to the issue of arbitrators. Now, arbitrators are a funny lot. They're a busy lot. So it's important to them to have accessibility to the venue. It must be very well connected. They shouldn't be forced to go around and have 3 stops before they get to their venue. Language is important. Decent hotels are important. And of course, Tashkent being a beautiful, old, very famous classical city, there is much to see. And arbitrators, let's face it, like to go to places where there are things to see. I can see their point.
So do lawyers.
So that's not really an issue with Tashkent. Yeah, absolutely.
Apparently, many of us don't get those interesting appointments.
That's true. That's because the first guys who are asked are the as you say, the white pale and stale gentlemen, and they like going to new places. But no, let's not go there. The question also, which arises with, say, a new jurisdiction and a new venue, is what is the pool of talent available locally or close by? So if I go to, well, let's not take London. London's an extreme example, or Washington or New York. If I go to anywhere in Europe, I know that I will have experts. Okay, they may come in from London. I will have experts available. I will have top lawyers available, top barristers available. And it's much more convenient for them. So that is something which you must remember to develop as a pool. And this is something which TIAC should actually concentrate on doing, developing relations with associations, engineers associations, scientific, technical guys, so that they have that pool and they can tell their people that, look, don't worry about it. We have a data bank of this sort of stuff. So that's important when it comes to physical spaces. I'm sure that there are state-of-the-art physical spaces that are being put in place. A couple of things that one must remember is we're dealing with a scenario where now even Indian clients are expecting that they will have live transcriptions, and they will be able to see that. Now, I know for a fact that that is highly specialized. It is highly expensive. It's really expensive. I mean, there are very few people who do this. A lot of them are based out of London, etc., and they charge by the hour. And it's not, but the facility is phenomenal. So it has to be done nowadays. That is something which we, for example, at the MCIA, will also arrange for it in Mumbai. But there are no local people who can actually do that kind of stuff. It is really high-tech stuff, as we've all seen. I mean, they sit in the room, and I mean, they're just phenomenal what their journey out there. I think that even Singapore, in that sense, which is so much down the road, further down the road in terms of being established, it doesn't have the pool that, for example, London or Washington or Paris have. Not yet. I mean, but so it takes time to develop. I don't see that there's any problem with that. The other issue is that I see that the government over here has been promoting and helping the institution. That's very important. The government backing is important. And I think that when it comes to Enforcement, I agree completely with the others that it's not an impediment, that it's civil law and that it's, but I do think that there are, I don't quite agree that every high court is the same. We are still from time to time, I mean, you're dealing with 20 odd high courts, some of the big ones with 40 and 60 judges. They all have their own views. I mean, we've been at the receiving end of horrendous judgments when you go for, I mean, you get the stray chap who just goes off on his own to set aside things. Now, apart from that, it's really interesting that there has been this move to have, in fact, a full session tomorrow on diversity. And of course, it's been mentioned before, Jaya is a past master at this. And on that note, I think I'll just pass it back to Jaya, and she wants to take that up further, and to Vivek. Thanks.
I have one question for you before we get to the topic of diversity. Now, the pandemic has been once in a lifetime disruptor, and it has changed the way we arbitrate. It's changed the way we do a lot of things. 1.5 years ago, a panel like this would be in Tashkent, and if you can't come, there's no invite. Now we're doing it online with all of us sitting in different places. Now, with the mainstreaming of the video call, how important are facilities and issues of connectivity going to be? Because do you think we'll go back to a world where it's back to the old normal of getting into a flight, flying somewhere, spending so many days doing your arbitration, getting out? Or are we in a new arbitration world?
That's really an interesting question. And I'm not quite sure what my crystallized view is, but I think we will get back to in-person hearings to a large extent. I have had situations where a witness couldn't travel, so it had to be hybrid. And it is just not the same if you're cross-examining a witness. I mean, we've had problems where their lawyers were there along with us and were prompting them. And we got a phone call from our chap saying that, look, this is what's going on. So I mean, I'm not sure that ultimately there is a complete substitute in virtual hearings at all. And it's very important to also be in the same room, to be able to understand and to see what the tribunal is, how it's reacting. You can't quite do that this way. There will be, to some extent, for cost purposes, I think hybrid hearings are likely to be much more prevalent than they were earlier.
I can't agree more with you on that. Last month I cross-examined one, and there was somebody whose shadow was coming in, and you could see that, and it was a complete circus. But anyways, I'm going to hand it back to Jaya, but I would invite all our listeners to start sending in questions. We are getting to the question hour time. Jaya, back to you.
So thank you, Vivek. I just wanted to make a comment about technology. And earlier we had this discussion about appointment of arbitrators. I think in today's age, we need also an arbitrator that is technologically savvy. Yes, while they have a counsel as well as the arbitral institution may provide the infrastructure for holding virtual hearings. But I think arbitrators must know how to use technology because without that, they won't be very effective. So now more and more evidence too and other exhibits are being shared electronically. So they must have that ability to understand understand how technology works. And another issue that's related to this is cybersecurity, because now if we resort to virtual hearings, cybersecurity has become a big issue, particularly in high-profile cases. And so that's a whole new topic that I think that parties should bear in mind when they're looking at doing a virtual arbitration. So there are a few issues that we didn't touch on, but maybe we can entertain some questions from the audience. Did somebody have a comment? I heard.
Yeah, so I think just on the physical versus electronic, I think I wholeheartedly actually agree with what Farhad just said. You know, and I'll try and break down why the reason for that. Perhaps we will see some online hearings as far as the procedural hearings are concerned, but the more reputed arbitrators, at least in India, they are men of age, right? So a lot of them don't take to technology very quickly. Perhaps even I don't take to technology as quickly as a fresher lawyer.
You don't need to be polite, Shank, to make the right point.
Now that's one aspect. The second is, you know, as Farhad said, you know, if you have to cross-examine a witness, 7 witnesses over 25 volumes of document, it's a completely different ballgame, right? I mean, you can have electronic surveillance that the witness is sitting alone, not prompted, all of that, but you know, it is more hassle than ease. So we will eventually, at least on the critical days of hearing, we would need to move to physical hearing, and more so. Oftentimes, at least in India, we're still facing technological issues where if you have 3 different arbitrators from 3 different jurisdictions, there's time lag, there is video lag. So, I mean, sooner or later, you'll see 70-year-old men saying that, okay, let's meet in Bombay, Singapore, Tashkent. So we can't wish it away, as much as I would personally like to sit at my home and do everything, but that's not how everybody else will. So I think to go back to a point which Farhad made about accessibility, I think direct flight to Tashkent from New Delhi will be a good start.
Yeah.
Thanks, Sean. One question, you know, Jaya raised a very interesting point, cybersecurity. Now, we don't have too much time, and there are a couple of things. Quickly, can all the panelists, you know, briefly comment, or rather, let me put it a different way, have your clients started talking to you about cybersecurity? Farhad, do you want to?
Yes, they have.
Yes, they have. Not quite with the level of alarm that you see in the West, but yes, certainly they've started talking about it. But the one point I actually stemming from what Jaya said is what the TIAC should also be very up to date and clued in on is IT support. Whatever happened, because we've had situations where in the middle of an arbitration, we had to phone up our guys, our IT guys in our office in Mumbai to tell these guys at the center how to go about things. You know, so I mean that's very important for TIAC to have in place. I mean, their guys should be completely clued in, their IT guys. But yeah, increasingly people are going to be asking about cybersecurity.
Thanks, Farhad.
So there's a question in the chat. Sorry?
Yes, there's a question.
There's a question in the chat box related to the virtual hearings. Does TIAC have a protocol for virtual hearings? So, Vivek, do you know? I'm sure they allow for virtual hearings. They probably will have some protocol, although I've not seen it.
I'm honestly not aware, and I think Suvaksh Vasudev's asked a very important question, and I'll read out the question for the benefit of everyone who might not have seen it. Does TIAC offer facilities for virtual hearings, and if there is a virtual hearing protocol in place? I am sure the way TIAC is developing, they will very soon have this virtual hearing, but I am not aware if they do have or not, and I am also not aware about a virtual hearing protocol, though I see maybe Jaya has something to add to that.
I think they do have a virtual hearing, because when I read the rules, they said there's an ability to conduct virtual hearings. So I'm assuming there's a protocol associated with that to have virtual hearings. That's there in their rules. I saw it when I was reading it. So I guess my uncertainty was, you know, I've not seen the virtual protocol. So so here's a question from the audience. Another question. I need to wear my glasses to see it. And the question is, Does the panel feel there is a dire need to implement or perhaps incorporate stricter protocols or follow some international regime of law so far as cybersecurity is concerned to ensure accountability as part and parcel of the arbitration? Before I have others chime in, I can say that many of the arbitral rules here in the US, they impose on the arbitrators and mediators handling a particular case, they impose a responsibility on these dispute resolution professionals to ensure that they're not hacked, that they follow certain protocols for sending emails, it's encrypted, and so on. It's their responsibility as a sitting arbitrator or a mediator to make sure that they are following all the protocols for cybersecurity, as well as to ensure that they are using encrypted emails and so on to ensure that they're not hacked. So that is a big difference now after all the hackings that have occurred. So TIAC may want to look into that. It's a way to ensure, because as an arbitrator, as a mediator, if you're going to be held liable, you just want to make sure you're protecting yourself. And what are some of those steps you can ensure? So I've had to take courses that the AAA organized to ensure that we understand what steps we need to take to prevent hackings, and also to ensure integrity of the information that's being exchanged during the arbitration or mediation.
Yeah, top 2 tips, please.
Pardon me?
I said top 2 tips for everyone.
Oh, I see. So I don't see any other questions here, but I wanted to just highlight a few topics that I've gathered from listening to other sessions, and I think it might behoove us to discuss them here. In one of the sessions yesterday, they talked about a survey that had been conducted of investors to see what issues they felt was important for conducting or for a successful arbitration. So one of the issues that was raised, we've talked about a lot of them here today, but I think we need to also discuss or look at the political stability of the country where you are conducting the arbitration or under whose rules you are arbitrating. So that was one important aspect that the investors brought out. The other was the ability also to have electronic, because if you're going to be doing these virtually, there has to be some kind of a protocol in place as to whether they're going to allow electronic signatures. In the US now, in all the courts, they've migrated to electronic formats for all aspects of the case management, and they allow for electronic signatures, and there's a protocol you have to follow how you sign off on a document. So that is another issue that was raised. And another important issue, I think, that is there in the TIAC rules, which we didn't talk about today, is third-party funding for arbitrations. So would any of you like to comment on any of these topics that I just mentioned?
Yeah, I'll just take a dig on that. In fact, I was thinking of the same point that third-party funding finds such it's a very proactive step. And like I said, it's ahead of its time that it actually finds a mention in the rules for recognizing third-party funding as a way of, as a part of the process, in fact, where we are still struggling to see enforceability of that in India. We often come across these questions here. It's very prevalent otherwise everywhere else, but it was a very welcome step to see that very specifically mentioned in the TIAC rules, in fact. I just wanted to also answer to this question, last question raised on the accountability part, and I felt that I could just share experience. See, what typically is happening today due to pandemic, that we have forcefully moved into a virtual space, and data confidentiality, and as what I mentioned, that confidentiality extends to the fact or existence. So it is a duty on the tribunal today to ensure that there is no breach of any of this information which we are doing virtually, and there's no hacking. Essentially, hacking would mean that we are dispensing information and dissipating information which is not really meant to be known to certain class of people or to be outside of the room. So we've got to have a very important room together. I mean, that has to be locked in, where where we conduct an arbitration. Typically, what we would do in India for years, till the time the changes happened in the Indian arbitration law, is that a party will pay for a place, and then the next time the other party will pay for the place. We'll go to a third place in a hotel or something, and we organize arbitration so that everybody comes in and goes. Here, there was an important question that would we let the same thing happen, and would we make a party a host for, let's say, organizing a Zoom call, or or any other mode of conducting that operation. And in fact, this is all the more relevant for the tribunal to actually provide for such facilities, because it is the impartial, it is one who will not let any of the party control the proceeding, and it can control proceedings, in fact, as a neutral authority and institution. And I think it's very important to, at least till the time we are on the virtual space, to have that in play by the tribunal itself. Otherwise, we'll often have to go outside and hire somebody whom we would like to believe that is going to be impartial and would not allow a hack or an information leakage. Because when we do arbitrate, and when we do participate in an arbitration, we are very candid with our arguments, and there are a lot of confidential information which we are sharing. And the whole intent and purpose of keeping that confidential to the extent that is envisaged in the rules would be gone, and would be OTOs if we don't let that happen. So it's very important. I think it's a very relevant question that came from Subhiksh Vasudev here. And that onus should ideally fall onto the tribunal to organize a virtual room of such nature that no leakage is possible.
Let me make a quick comment on these three issues. So on the security or the data of the potential breach issue, I think whoever is being given the responsibility, unless it's the organization or the institution, neither party will be happy to take that responsibility. None of the arbitrators will be happy to take that responsibility. And therefore, the best solution is, okay, now let's go back to physical meetings and physical hearings. So, I mean, if I were a party or I were an arbitrator, I'll no way on earth that I'll say I am taking responsibility of the security of what is being exchanged here. So that's not going to happen, number one. So if the institution is not going to take care of it, we will fall back on physical hearings more sooner than later, number one. The other point of discussion yesterday was the political stability. Now, and we can, I did do some research last evening on the political stability index. When we compare India and Uzbekistan, yes, we are ahead, but not so far ahead, right? But what does it really mean in terms of the practice and the kind of work that we do? Irrespective of the political lack of stability or the stability itself in a country, the area in which we operate, and all of our colleagues here and all of us here perhaps don't relate to the instability in our respective countries, right? Typically, legal professionals above a certain standard, engaged by a certain class of clients, are supposed to be, have a lot more integrity, etc. So yes, political stability could be an issue, but we are not dealing with Bolivia here. I mean, we are talking about Uzbekistan, and no disrespect to any other country. India and Uzbekistan are not too far apart, though India is a bit ahead. So I think political stability has to be seen in that context. The third issue was the third party funding. Now, while I agree with Ashish that third party funding has been thought of, at least in the IAC rules, I'm not too sure if that's a great step ahead. And I'll tell you the reason for that. Most countries, okay, forget most countries. When I'm talking of India, while I personally have a position on third-party funding, on its validity or invalidity, but the fact is there's a huge amount of confusion about the legality/illegality of third-party funding in arbitrations or litigation in India. Now, I personally believe that it's not an impediment, but there may be several other jurisdictions where third-party funding is not very clear. UK is one where it is very clear. There are organizations, institutions who do this as a profession. In India, we are seeing a lot more third-party funding happening, but those third-party funding actually go through some serious FEMA and corporate law structuring to ensure that third-party funding actually happens, right? So the TIAC rules actually says you have to declare, a party will have to declare if there's a third-party funding. Now, I'm not too sure with the confusing or at least developing third-party funding rules and law, at least in India, any party would be happy to take this, adopt these rules and then subject themselves to make a declaration that, yes, I have taken third-party funding. So, I mean, we have to see that in a little more, we have to see it a little more carefully.
Could I just add to that, Ben? A short point. We've looked at it. Indian clients who were going to arbitrate anyway looked at it to the point where we almost arrived at the agreement, and the client then turned around and said that, look, this is far too big a chunk of what we will earn, and we'll manage, but we'll pay ourselves. So third-party funding is great when for an Indian party when he can't go. If he doesn't get the funding, he can't afford it. It's not so good when you're dealing with a slightly bigger company that will be stretched, but it's not impossible for. So there's something there. I mean, I'm not sure that considering the amounts that are taken away by third-party funders, Indian clients in general are not that keen if they can avoid it.
Good point. Now, we need to wrap up, and I see Ashish wants to make a point. So, Ashish, it will have to be brief, very brief, because there's another
Thank
session.
you, Vivek. Thank you. In fact, my first thing I wanted to check with, do we have the time to actually comment any further or not? So I'll make it very brief, in fact, and I think the rule of the game for me to ever advise on a place or not on a place is to actually know the rules in advance backwards. So all the points that we have discussed actually today, whether third-party funding or the ability to communicate very clearly with the tribunal, or let's say enforcement and civil versus common law. I mean, before I take the first step, actually, I would like to know the rules backwards, actually, right from enforcement. And that will be my advice. In fact, to that extent, I would actually urge the TIAC to actually bridge these gaps and let us all know how backwards can we work and how, to what extent is the efficiency going to be in play. With that, I'm trying to be as brief.
So I'd like to thank you for that comment. I'd like to add one last comment related to what Ashish just said. And earlier also in the discussion, I think Chakrapani talked about the role of courts. I would like to make one point here, and that is that the TIAC and also UzAW law is focusing on capacity building of judges so that they understand their role in the arbitral process and when to intervene and when not to intervene. So I think we didn't talk much about that aspect of the capacity building for judges, but that is something that I think is a very proactive as well as an attractive element of the TIAC Center and the rules. So with that, I think the time is up, and I would like to thank all our panelists for leading us into this wonderful discussion. I hope that the participants found this to be a useful and valuable session, and you got something out of it. And as for TIAC, I hope that we have helped you in some way to maybe enhance your rules further. So with that, thank you all and have a wonderful day.
Thank you very much.
Thank you. Thank you.
Have a good day.
Thank you.